All right, one moment, please, and I'll get the record started. The 37th Circuit Court is now in session with the Honorable Brian K. Kirkin presiding. It is Tuesday, April 9, 2024 at 8:31 a.m. And this is for case 2015-1447 DS, Alexis Tabaka versus Christopher Tabaka. Attorney Elaine for defendant.
Good morning to all of you.
Good morning.
Morning.
I wanted to just clarify on the record, I did get, our office did, I didn't, but our office did get a call from Miss Elaine last week in which she informed us that she was withdrawing the motion to show cause for failure to pay attorney fees as they had been paid. She also informed us, Ms. Tabaka, that you were withdrawing your motion for attorney fees. Is that correct?
Yes, Your Honor.
Okay, thank you. So we are basically proceeding on the two motions to show cause in this matter. One filed by defendant, one filed by plaintiff. And maybe you could, I guess, tell me, I'm not certain now, I didn't have the dates as to which motion was filed first.
Ours was filed first, Your Honor.
I thought it was, you filed yours back in when, October, November?
October,
Okay.
Your Honor.
Okay. So we'll make you, Ms. Elaine, the moving party, at least in regard to that. So is there any preliminary matters before we commence, Ms. Elaine?
I don't believe so, Your Honor.
Ms. Tabaka?
No, sir.
Okay. Ms. Elaine, do you wish to make an opening statement or proceed to your proofs?
I do, just a brief opening.
Okay.
Yeah, this court is familiar with the issues surrounding what I have called, through the history of the proceedings, the work parenting time provision of the parties' 2015 custody order. As a brief reminder, the parties designated parenting time so that if Alexis was working, Chris would be afforded that parenting time. And as this court will, I'm sure, recall from our first show cause hearing on this particular issue, everything had gone fine with that work parenting time provision until Alexis got angry with Chris in the summer of 2021 because he filed an ex parte order regarding contact with her boyfriend, which resulted in a no contact. And from that day forward, Alexis has done everything in her power to ensure that Chris does not get the children when she works, including violating the order repeatedly, and now to the extent of becoming voluntarily unemployed for a significant number of months so that she could not, so that she wasn't working, so that she would not have to give the children to Chris. It's really outrageous. It's a sad situation because she's punishing these children and keeping them away from their father for her own petty vengeance. Now, this court held a show cause hearing on the violations that we alleged, and an order entered on September 15th, 2023, and awarded Chris 39.5 hours of makeup parenting time. The court also ordered that Alexis pay half the attorney fees for that proceeding, which she has now done. The subject of the last show cause hearing were violations of that work parenting time provision up through November 9th of 2022. And today's show cause involves her violations from that date up through June 23rd, 2023. And the reason for the gaps, I guess, is because by the time we got to the show cause hearing, there had been more violations. And then this hearing will encompass those that had occurred up until that hearing, and then those following that hearing up until June 23rd, 2023, which was essentially the end of her work with the Calhoun County Sheriff's Office. Notably, Your Honor, we deposed Alexis on August 12th, 2023. And at her deposition, I presented her with her timesheets, and I presented her with our spreadsheet, which is our exhibit A or B, A, I think today. That spreadsheet, what we claimed were the violations of the work parenting time provision, the dates and the times of those violations. And we went through every single date on that spreadsheet with Alexis at that deposition. And in short, and we have her deposition here today, she testified that the work hours listed on her timesheet were correct. So she validated all of those. And she testified that if the times we had identified on our spreadsheet were indeed her parenting time, then yes, she had violated the work parenting time provision by not allowing Chris to have the children. And we, after that deposition, Your Honor, tried to avoid this hearing. We tried to avoid taking up this court's time, and I'm saying this because I think it goes to the claim for attorney fees that we will make today. After the deposition, we sent a demand letter to Alexis's prior counsel demanding, essentially saying she admitted these violations, and this forms the foundation of our claim. And so we demand this makeup parenting time. We provided the timesheets, we provided the deposition references, etc. And we were denied that resolution and were forced to take this matter to court. So all in all, Your Honor, there are a couple errors in the timesheet that I'll go through just through the testimony, but at the end of the day, there are 53.5 hours of makeup parenting time that Mr. Tabaka is entitled to. And we would like this court to order that parenting time be made up to him in the following ways. He would like to select 3 to 10 hour blocks of parenting time. Just like the last time, he would provide 7 days notice of the dates that he wants this makeup parenting time to occur. And he would agree, just like last time, that he would not be able to choose and supersede any of Alexis's set holidays. We would also ask, Your Honor, just like last time, that attorney fees for this proceeding be awarded, which would include some of the deposition time, not all of it, but some of it spent on this piece, the efforts to settle, the show cause motion itself, this hearing, and a couple false start hearings that we've had up to this date. Thank you.
Okay, thank you. Mr. Tabaka, do you wish to make an opening statement, or you can reserve your opening statement, or you can waive your opening statement?
I'm not entirely sure how it works, Your Honor, but I'll make an opening statement.
Okay,
Just in regard to most of what Ms. Elaine has just said is not true, and it is meant to mislead this court. And I have all of the evidence that we'll be going over today, including much of what Ms. Elaine talked about. And in the deposition that she is referring to, I did not make those admissions that she's claiming to the court. But that can be read from the transcript. I certainly have not violated your order that you put in place on May 12th. And I think that you will find, Your Honor, that almost everything in their claim actually goes entirely against your rulings for that date, which I will go over with exhibits. And I also have several witnesses to testify on behalf of me regarding a lot of the false things that Attorney Elaine just presented to this court. So I don't enjoy this, but I'm ready and I'm prepared to provide the evidence to show that those are untrue claims, that this is a frivolous case being brought upon me just to harass me. I guess that's my opening statement, Your Honor. I apologize. It's not glamorous.
that's fine. Ms. Elaine, you can call your first witness.
Yes, Your Honor, I would ask that the court sequester any witnesses now that Ms. Tabaka has said that she has some. I don't know where they're located and they may not be with her, but just in case they are.
Okay. Ms. Tabaka, any response to the sequestration request?
No, sir. Everybody should be attending in over Zoom. There's just one person, and my mother is in my home, and I will let her know that there's a request for her to be sequestered. So give me just one moment so she knows to not be in earshot.
Okay, thank you.
All said. Thank you, Your Honor.
Okay, thank you. Court will grant the request for sequestration. The court will inform any of the witnesses that may be viewing this through Zoom or in any other manner, that they are not to do so and are prohibited from doing so until such time as they have completed their testimony. And if I will state, in the event that a person does view these proceedings and we find out about that later, we could strike their testimony or they could be held in contempt of court. So with that, Ms. Elaine, you can call your first witness.
Thank you. I call Alexis Tabaka.
Okay, Ms. Tabaka, we'll have you raise your right hand and be sworn in.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
I do.
Thank you.
Go ahead.
Jesus, will you enable me to share my screen, please?
Yes, one moment. You should be able to do it now.
Thank you. Good morning, Ms. Tabaka.
Good morning.
Good morning. I'm going to show you what we have pre-marked as Defendant's Exhibit B. Just give me 1 second to get it up on my screen here. Just adjusting that size. All right, are you able to see that?
Yes.
All right, and could you identify this document? And for the record, it's 25 pages long. It starts with a business record certification, and then the second sheet is entitled Calhoun County Hourly Employee Timesheet 2022. Do you recognize this?
I recognize it to be, it's a time card from work.
All right, and I submitted our exhibits to you in advance of this hearing, correct? So you've had a chance to look through this?
I have not had a chance to look through this, but it looks like what you brought up at the deposition.
Okay,
Ms.
and you
Ms.
would-
Elaine, Ms. Elaine, if you
Yes.
could, you had filed those proposed exhibits. Would you identify what it was, how you identified them in the proposed exhibits so I can follow?
Sure, Your Honor, and there were two sets. If you recall, we had been before this court a few months ago we were going to start this hearing and ended up not starting it. So there was a set of exhibits that were delivered to the court for that hearing. And I don't believe that I had letters on those, but there were only 4 exhibits. And then there was a second set because we added different hearings to today. And so there was another set of exhibits delivered last week. Those do have letters, but this one is in the first set.
Oh, that's in the first set, okay?
Yeah, so the first page will look like this, business record certification, and it's a 25-page document.
Hmm.
Okay, what we're gonna have to do is we're going to look that up. We had the second set from last week, but I didn't have the first set, so I'll get that. So go ahead.
Okay, would it be helpful if I emailed anything to any of your staff?
Yes, let's do that and I can print them off. Yes.
All right, can I just have 1 moment to do that?
Yes, go ahead.
All right, thank you.
That would be better.
And if you could excuse me just a minute, I believe that there's an alarm going off in the house and it's making noise in the background.
Okay, go ahead.
Thank you.
The exhibits that you guys have start with E from last week, is that accurate?
Yes.
Okay, all right.
And the one that you're going to do now, what are you identifying that as?
B, Your Honor.
B?
B, correct.
Okay. You can go ahead, Miss Elaine. We'll,
right.
when we get those, I'll be able to review them.
By the way, did you email those to me or Christy?
To you.
Okay.
Do you want me to email them
Not
to Christy?
showing.
I wonder, hang on, let me just check the size. Should be. I haven't bounced back for size. That's a good sign. Anything yet?
Not yet. Oh, wait, hold on. Is it 4 files, A, B, C, and D?
Yes.
Okay, it's just gonna be a moment. We'll get it, print them out and judge what happened.
Okay, go ahead, Ms. Elaine, you can go
Okay.
and we don't
Okay.
need to hold up while we get those.
Okay, let me get back on that. All right, Ms. Tabaka, these time cards were ones that you signed and submitted in the course of your employment with the Calhoun County Sheriff's Office, correct?
Correct,
And you signed them as true and correct?
correct.
And you stand by that certification today?
Yes,
All right, so I'm just gonna start with Wednesday, 11/9, and these would be from 2022. Worked 8:30 to 12:30 PM, correct?
correct,
And that was your parenting time day that day, correct?
correct.
And you did not allow Chris to have the children while you worked, is that accurate?
I only worked a half a day.
I understand that, but at no time during that day did you allow Chris to have the children?
He did not have the children that day, if that's what you're asking.
It is. And on 11/15, which was a Tuesday, you worked from 8 to 4,
Correct,
and that was your parenting time day?
correct.
And Chris did not have the children that day, correct?
Not to my knowledge, no.
Blow this one up, skipping that one. On 11/18, which was a Friday, you worked from 9 to 12:30 PM.
Correct.
And do you recall that this was a snow day?
I do recall that it was a snow day and that Chris did not request to see the children or receive the
Right,
children that day.
And you did not tell him that you were working, correct?
That I do not recall.
Okay. 11/23, you worked from 8 to noon and 1 PM to 4 PM, correct?
Correct.
And that was your parenting time day?
It was,
And Chris did not have the children on that day.
not that I'm aware of.
11/29, you worked from 9 to 5,
Correct,
and that was your parenting time day,
correct.
and Chris did not have the children on that day. Correct?
Well,
From any time between 9 and 5, he did not have the children.
he did spend time with the children between those hours. And I apologize for not making this a yes or no answer, but that pertains to the other date, which was also piano day. Chris would always be with Maddie from the time she left school at 2:30 until the time she ended her piano lesson at 3:30. So he was actually spending time with the children on that date. I didn't stop him. But that is part of that time. Yes, he did spend time with the children on those days.
Not by arrangement with you because you were working, correct?
Can you ask your question again?
Sure. To the extent you allege he spent or saw the children after school that day, that was not by any arrangement between you and him. Hang on.
No, he's at the school every single day on my parenting days. So,
And you don't approve of that, correct?
I don't think that it is.
Yes or no, ma'am? You don't approve of that?
I don't approve of having to see my ex on my parenting days.
All right.
It's
You
not
don't-
necessary.
You don't approve of him coming to the school outside of his own parenting time. So if he was at the school that day, that was not by agreement with you pursuant to the work parenting time provision. Is that accurate?
Ask your question again. I'm sorry.
Yes. If he was at school that day on 11/29, that was not part of an agreement with you pursuant to the work parenting time provision.
Thought that was his own free will.
Okay, so your answer is no, it was not by agreement with you pursuant to the work parenting time
That's
provision.
kind of a long answer and it's too much for me to, he was there on his own free will.
All right. And on 12/2, Friday, was that your parenting time?
What was the date again?
12/2, Your Honor.
12/2, okay.
Was
Yes.
that your parenting time? And you worked from 9 to 4 that day?
I did,
And Chris did not have the children that day, correct?
correct.
And on 11/7, was that your parenting, I'm sorry, December 7th, 12/7/2022, was that your parenting time?
Yes,
And did Chris have the children that day while you worked,
not that I'm aware of,
and you worked from 9 to 5?
correct,
And on 12/13, you worked from 9 to 5?
correct,
That was a Tuesday.
correct. It was a piano day,
And Chris did not have the children that day pursuant to the work parenting time provision, correct?
other than his exercising parenting time of his own free will.
And on 12/16, was that your parenting time day?
Yes,
And you worked from 9 to 3:30?
I did.
And Chris did not have the children that day, correct?
Unless again, he was exercising parenting time of his own free will and Maddie was at school till 5 p.m. that day for a dance.
And did you let him know that you were working until 3:30?
I don't know.
On 12/22, that was your parenting time day?
12/22.
My apologies, 12/21.
Yes, it was.
And you worked from 8 to 5 that day?
Correct.
And did Chris have the children that day pursuant to the work parenting time provision?
Chris had the children that day on his own free will. The children had math Olympiad and piano after school.
Okay, did you make arrangements with Chris to have the children pursuant to the work parenting time provision?
I do not believe that the judge put that in order until May 12th. You keep referencing that, but that was something that the judge required me to do in his ruling from May 12th forward.
So, all I want to know is the answer to the question, and then you can make certainly whatever arguments you want to make during your case. But my question to you was, did you arrange for Chris at all via either his request or your information to him that you would be working, that he would have the children on 12/21 pursuant to the work parenting time provision?
Not that I'm aware of.
Same questions for 1/10. Was that your parenting time, January 10th?
Yes,
And you worked from 10 a.m. to 6 p.m.?
yes,
And Chris did not have the children pursuant to the work parenting time provision on that day at either, correct?
correct, other than his own free will.
Well, hold on a second, just to clarify, because I need to, Ms. Tabaka, when you said he had the kids on his own free will, just so I know on what dates that you've talked that he had the kids. So don't say he's had the kids on his own free will. If he had them, I want to know whether he had them or didn't have them.
Yes, sir. And I'll go back over that again when we go over this, but every piano day, which are most of the days on this list, Chris would, even though it was my parenting day, show up to the school when Maddie gets out at 2:30, and he would remain with Maddie from 2:30 to 3 when her piano starts, and then also remain at the piano lesson from 3 to 3:30. So for an hour's time, he would be with her on those days that they're claiming.
And Your Honor, I would object to that testimony based on foundation.
Well, I'll take the answer because I asked the question. I think it's relevant.
All right, and Ms. Tabaka, what is your foundation? Do you know what I mean by foundation?
Not necessarily, but I have witnesses that
Okay,
will attest to his presence, if that's what you mean.
Okay, it is what I mean. How is it that you are able to testify to that from your own personal knowledge? Do you have personal knowledge, meaning you observed Mr. Tabaka? Do you have that sort of personal knowledge that you observed Mr. Tabaka with the children?
I have witness that has observed.
Okay, I'm asking you a specific question. Do you yourself did you observe him on the dates in question?
No, not with my eyes.
Okay, did he tell you on the dates in question that he had been with the children?
He never informs me when he is with the children on my parenting days.
So the answer is no, he did not tell you that, correct?
No, ma'am.
Okay. So 110, I think we covered, right? You worked from 10 to 6. And it was your parenting time day, right?
Mhm. Yep.
All right. 123, you worked from, and Your Honor, this one is not on the spreadsheet, and it's one of the corrections we had to make today. There's 2 corrections, that's one of them. 123 of 23, ma'am, you worked from 9 to 5, correct?
Your Honor, may I make a statement real quick?
No, you can answer the question. You can make a statement later.
Yes, sir. 123.
That would have been Monday, Miss Tabaka, a Monday.
Mondays, Attorney Elaine, are never my parenting days. They're always Chris's. So I'm not sure what you're getting at there.
Well, that's what I wanted to know, if that was your parenting time day. So you say that 123 was not your parenting time day?
No, Mondays are never my parenting days.
And what is Chris's parenting time on Mondays?
If it's a school day, he gets them when they get out of school.
Okay. And 127, was that a parenting time day of yours? That was a Friday.
Yes,
And you worked from 9 to 3:30?
correct.
And to the best of your knowledge, Chris did not have the children pursuant to the work parenting time provision that day, yes?
Correct. There would have been no time in there.
2/1, February 1st, which was a Wednesday, did you work from 9 to 4:30 p.m.?
Yes,
And Chris did not have the children that day, and it was your parenting time day?
other than the time he spent of his own free will.
All right, I'm gonna ask you not to testify to that anymore because you don't have that personal knowledge, and you are free to bring on your witnesses. But if you don't have that personal knowledge, you can't testify to that. Does that make sense?
Sure,
All right. So he did not have the children on 2/3 pursuant to the work parenting time provision, correct?
sure,
And on 2/15, that was a Wednesday, you worked from 11 a.m. to 4:30 p.m.
correct.
And that was your parenting time day?
Yes,
And Chris did not have the children pursuant to the work parenting time provision, correct?
that's my knowledge.
Same with 2/21, was that your parenting time day?
Yes,
You worked from 10:30 a.m. to 4:30 p.m.
correct.
And Chris did not have the children that day either pursuant to the provision at issue.
That's my knowledge.
Same with 2/24, you worked 6:30 a.m., I think that says to noon.
Right.
And Chris did not have the children at any time during your parenting time?
Nope, that was another snow day.
All
That-
right, so
yeah.
the children were not with you because you were working during the snow day, and then they were not with their father, correct?
Well, the children were already with me because it was a Friday and school was canceled because of the bad roads, and he did not request to have the children or come to get the children to travel on the roads to get them.
Did you let him know you were working?
I do not recall.
All right. 3/1, the only way that the two of you communicate at present is our family wizard, correct?
Correct.
And so if there had been communication about that day, we would find it in our family wizard. For instance, if you said, hey, I have to work.
Correct. But of
Alright.
course, as I
Okay.
mentioned before, the judge did not
Thank you.
rule that until May 12th.
Yep. March 1st, you worked as well, and that was a parenting day of yours, correct?
Correct.
And Chris did not have the children pursuant to the provision?
To my knowledge,
Same with 3:15, you worked from 9 to 4:30,
correct?
your parenting time?
Pardon?
That was your parenting time?
Yeah, that was my parenting day.
And Chris did not have the children?
Not to my knowledge.
3:21, you worked from 10:30 AM to 5.
Yes,
That was your parenting time day?
it was.
Ms.
Kristen,
Elaine, what was the date of that again?
That one was 3:15, Your Honor. 3:20, sorry, we did 3:15 and 3:21 on this page. I think that was
21, okay,
3:21.
thank you.
Yeah. All right, and Chris did not have the children, Ms. Tabaka?
Not to my knowledge.
That one we had marked, but then we ascertained that was a night work, 10:30 PM. So we're gonna skip. We're not asking anything from 3:31. 4:10. You had the children, or you say Monday was his parenting time?
Correct. Mondays are his parenting days.
Okay, yeah, so on our chart, we don't have that one. 4:12, that was your parenting time day, correct?
Correct.
And you worked from 9 to 4:30?
Correct.
And Chris did not have the children that day pursuant to the provision?
Well, I don't believe so.
4:18, same question, your parenting time?
Correct.
You worked from 9 to 5?
Correct.
And Chris did not have the children.
To my knowledge.
4:21, was that your parenting time? It was a Friday,
Yes,
and you worked from 9 to 4?
correct.
And Chris did not have the children.
Not to my knowledge.
4:26, your parenting time day?
Correct.
You worked from 9 to 4?
Yes,
Chris did not have the children.
correct. To my knowledge.
4:28, your parenting time day?
Correct.
Worked from 9 to 4?
Correct.
Chris did not have the children.
Not to my knowledge.
5:05, you worked from 9:30 to 4?
Yes,
Your parenting time day?
yes,
Chris did not have the children.
correct. Not to my knowledge.
5:16, your parenting time day?
Yes,
You worked 9 to 1 and 2 to 4?
yes,
And Chris did not have the children.
correct. Not to my knowledge.
It's a little small. $5.19, was that your parenting time day?
Yes,
And you worked from 9 to 2?
yes,
And Chris did not have the children during your parenting time, correct?
well, I was out of work before my children got out of school and I picked my children up from school that day. So I'm not sure why that's up there.
You picked them up from school on 5/19?
Yes, I did.
Did you tell Chris that you were going to be working and that he could pick them up from school that day?
I do not know.
I'm sorry, what?
I don't know, but I know that I left work at 2:00 so that I could go pick my children up. 2:30 when Maddie gets out and 3:40 when Daniel gets out.
Oh. Ms. Tabaka, at the last show cause hearing we had on the work parenting time provision, do you recall testifying about your belief that when Mr. Tabaka would ask you to let him know when you would be working or let you know via our family wizard that he wanted to exercise parenting time during your work, that he was harassing you?
I don't remember specific communications.
You don't remember specific communications, or you don't remember testifying that you believed that he was harassing you?
Honestly, I don't remember a lot from that long ago, but generally speaking, I wouldn't be surprised if I said that he was harassing me because he's done it to me for over 10 years.
So when I'm talking about harassment in this context, I'm talking about the specific allegation that when he asks you about the work parenting time provision, you respond that he harasses you, or you opine later that he's harassing you. Do you agree with that?
I can't agree with that.
In fact, you've put it in pleadings that he harasses you by asking about work parenting time provisions, correct?
I don't know.
All right, I'm going to show you a pleading dated, one that you signed on 7/27/2022, and it's entitled Plaintiff's Answer to Defendant's Motion for Order to Show Cause and Request for Makeup Parenting Time. All right, let me just show you the start of that. All right. So this is when you were represented by Mr. Schaefer, Alexis, and then I'll just skip down to this. That's your signature?
It is.
All right. And with respect to the work parenting time provision, your answer to number 6, you're talking about the work schedules. And then you say defendant has gotten to a point of harassment and making demands that are detrimental to the well-being of the minor children, correct?
That is what it says there, yes.
Okay. And I would just note for the record, Your Honor, in the show cause hearing transcript from May 12, 2023, there's a long discussion with Ms. Tabaka about Chris's request for the work parenting time provision to be exercised, characterized by Alexis as harassing from pages 12 to about 15. And that transcript should be in the file. Ms. Tabaka, the days that the children have piano, there's no court order, is there, that Chris cannot have the children on piano days when you work? Do you agree with that?
I'm sorry you broke up. I didn't hear the last part of what you said.
Sure. There's no court order that the work parenting time provision is not exercisable when the children have piano and you are at work, correct? So in other words, let me state it a different way. If you're working and the children have piano, the work parenting time provision is still in effect, correct?
I really have no way of answering that because that order was written during preschool and daycare years where piano and extracurricular activities weren't even a part of the children's life at that time.
Right, but we went through a lengthy proceeding and the court gave an interpretation of that order. And in that interpretation, Mr. Tabaka is entitled to have the children after school if you work, no matter what their activities are. Would you agree with that?
I would absolutely agree that Judge Kirkham did say that moving forward from the hearing on May 12th, that Chris would be able to facilitate those activities instead of my mother if I was working.
Well, as a matter of fact, the court interpretation of that was retroactive and he awarded Chris parenting time for the times that he had been deprived after school, correct?
No, Attorney Elaine, I do not believe that the judge awarded him any of those times that my mother was handling piano, that was meant as May 12th forward. And from May 12th forward, that has been not violated at all.
So your testimony is that from May 12th forward, well, you quit work right after that hearing, right? You quit.
No, I never quit my job.
You went out on leave, correct?
I was on personal leave, correct?
You were on a claimed medical leave, correct?
Correct.
All right. And you applied for that leave or inquired about that leave right after the hearing where Judge Kirkham held you in contempt of court, found you violated the work parenting time provision and said it was still in place moving forward, correct?
My inquiries for personal leave actually with the department long pre-existed that. That's just the culmination of when it ended up going into effect.
Well, that's not true either, is it, Ms. Tabaka? I'm gonna show
No,
you.
it is true. I'm sorry, Attorney Lane, it is true.
I'm gonna show you what we've marked as Exhibit G. Oh, and by the way, Your Honor, I would move to admit the time cards, Exhibit B.
Ms. Tabaka, any response to the offer of those time cards?
I don't know what that means, Your Honor.
Well, I'm inquiring whether you have an objection to the admission of those exhibits.
Does that just mean that they go into evidence?
Yes.
Oh, that's fine.
Okay, the court will admit defendant's Exhibit B.
Thank you. All right. Who's Brandy Aldrich?
Brandy Aldrich is Human Resources at the county.
The county where you were previously employed?
Where I am employed, yes.
You are no longer employed by the Calhoun County Sheriff's Office, is that accurate?
I am still employed by Calhoun County.
You have a job position open to you if you come back, but you are not working for the sheriff's office, correct?
There is no job position open to me at this time.
Okay.
However, I am still employed by the county in good standing.
Okay, so you're employed by the county, but you have a different job than you did when you worked for the sheriff's office as a bookkeeper. You're not a bookkeeper for the sheriff's office, correct?
Presently, correct.
And you don't work for the sheriff's office, correct?
I do not have a job position at this time with the Sheriff's Department.
Okay, all right. And this email from Brandy Aldrich to you is dated May 16th, 2023, which was a Tuesday, correct?
Correct.
And this person, this Miss Aldrich, is transmitting to you FMLA and short-term disability paperwork. So I assume you requested paperwork to be transmitted to you if she's transmitting it, correct?
Yes, this is the second time that she
Ma'am,
sent me this paperwork.
Just please answer yes or no to the question. And we had our final hearing in the first show cause on May 12th, 2023, where you were held in contempt of court, correct?
Correct.
And in fact, you did apply for Family Medical Leave Act, correct?
I did.
And then in your, I believe it was your deposition in August 2023, do you recall that I asked you to waive your HIPAA rights and provide a release so that I could receive your medical records?
I do.
And do you recall that at a later date, you did in fact sign a release and transmit it to me, waiving your HIPAA rights?
I do recall. Mhm.
And then do you recall shortly thereafter, and maybe the next day, you withdrew that request
I did.
and said you no longer agreed to the waiver of your right, correct?
Correct.
Okay. Your Honor, at this time, and I guess I'd like to ask you, Your Honor, how you would like to proceed. We dealt with the failure, the refusal to waive the HIPAA release, refusal to, I guess when she withdrew it, she revoked the HIPAA release that she signed. We dealt with this in the front of the court proceeding that is ongoing. I made a motion in limine, so because she has refused to release her rights, which she can do, I made a motion in limine to prevent her and prohibit her from giving any testimony with regard to her physical or mental health, which the referee granted based on the court rule. And I guess I'd like to know if Your Honor wants me to make the same motion in this proceeding, or whether Your Honor would just take the ruling of the referee and apply it.
We could take that ruling because there's no reason for us to again address the same grounds that were in a different proceeding. And that your understanding, Ms. Tabaka, is that the referee did rule that again that you could not offer testimony as to again the medical, et cetera, because of your revocation of the HIPAA waiver.
Yes, I do believe so, Your Honor.
Okay, thank you. Go ahead, Ms. Elaine.
All right.
Mhm.
Just one moment, Your Honor. So, Ms. Tabaka, you were off work from when to when, based on the FMLA?
Sometime in May until sometime in October.
And then what happened in October with regard to your employment?
Well, I cannot obviously talk about medical stuff. But I was going to return back to work. But my position was no longer available. It had changed hands, and the only position available was not accommodatable to the scheduling conflicts of the continued constant litigation ongoing in my life.
What do you mean by that?
That they couldn't accommodate an employee that had many schedule conflicts, all of these court dates, and appointments, again, at that time with my attorney. It was too conflicting with the needs of the job.
Okay. And when you say you were going to return to work sometime in October, that's because your request for extended FMLA got denied, correct?
I don't know.
You don't know why
I don't recall.
didn't you apply for additional leave and you were denied?
I don't remember.
Did you work for the sheriff's office in October 2023?
I did.
And do you recall when you worked for the sheriff's office in October 2023?
It was sometime near the end of the month.
I'm going to show you what we marked as exhibit. Actually, before I move on, I would move for the admission of G.
Mr. Tabaka, do you have any objection to the admission of exhibit G?
I'm not sure what exhibit G is.
Exhibit G is the letter from Brandy.
Oh, no, that's fine. Mhm.
Okay. Defendant's
All right.
exhibit G will be admitted.
Thank you. I'm going to show you what we've marked as proposed exhibit J. All right. And Joan Bowers was your boss at the sheriff's office, right?
She was a coworker.
Okay. And she transmitted these hours on your behalf. I assume you didn't fill out a time card for this late October week.
Yes, it was a different position that had different time recording that I was not familiar with.
All right. And when she says you worked 8 regular hours on the 23rd of October and the 25th of October, those would be what hours? Like 8 to 4, 9 to 5?
I don't remember, but it would be somewhere in that normal daytime work range.
Well, what were your hours at the other position?
In my position as bookkeeper?
In the position you were working, you said it was a different position in October or different hour.
Yeah, that was clerk in Marshall, and I think it was 8 to 4.
All right. So what about when you worked 3.5 hours or 3 3/4 hours? Do you remember what your hours actually were?
No, I don't.
So if 10/23 and 10/25 were your parenting time days, then did Chris have the children at any time during those 2 days when you worked a full day?
I don't know. I don't have any recollection of what was going on those particular dates.
Okay. And you did not stay at that clerk position past those October dates that we just showed?
Correct.
And I would move for the admission of J, before I forget.
Ms. Tabaka, any response to the offer of exhibit J?
No, that's fine, Your Honor.
Okay, court will admit defendant's exhibit J.
And why didn't you stay at that position?
because they couldn't accommodate the schedule conflicts in my life, because it is a front desk job where somebody has to be there from open to close.
Did you obtain any employment after that clerk job?
I had a casual, up to 12-hour-a-week job that I had applied for during my personal leave time, to do something productive and healthy. And that is the job that I'm working in now. It was never really meant to be like my main source of income, but it was a job that I had for work to do and that I've stayed with.
And who is your current employer?
Navigations Inc.
And what are your hours with Navigations Inc.?
Completely variable. Generally, I mean, when I started, I believe it was like 10 to 2, but sometimes it's 9 to 2 or 9 to 2:30 or 9 to 3:30. It just depends on the day. It's grounds work, so it's nothing that requires like set hours and set things to be accomplished in specific time periods.
Well, it sounds like the hours generally, and I understand you say they are variable, but generally they're during the normal workday, even though somewhat shortened, correct?
Yeah, they're during like daylight hours.
So how is it that that job can accommodate your busy court schedule when you're required to work from 10 to 2 or 9 to 2 or 9 to 2:30 and so forth?
Because it was a 12-hour-a-week job where those hours could be put in basically any time during the week.
Okay. So your testimony is if you have court, for example, you can just shift your hours to a different day that week.
Correct.
And who selected the 10 to 2 or 9 to 2 or 9 to 2:30? Who selects the hours that you have to appear for?
My supervisor, Dennis, communicates with me weekly to see what's in my calendar so that we can, plan for the following week's work schedule.
And did you inform your supervisor that you did not want to work any morning hours before, let's say, 9 o'clock?
No, it's all variable.
No, did you inform your supervisor that you did not want to work before 9 o'clock in the
I'm
morning?
not sure that I ever specifically said that, no.
Did you inform your supervisor that you had to be done with work by a certain time in the afternoon?
I let my supervisor know what days of the week are my parenting days and that I pick my children up at these specific times and they're accommodating to that.
All right, so you've made sure that your work hours are such that you do not have to offer Chris any work parenting time, correct? Any parenting time during your work hours?
Sorry. I make sure my work hours are such that I can have my parenting time with my children.
All right, and then Your Honor, I think I understood correctly at the beginning, but correct me if I'm wrong. We're just going to deal with this show cause, get this one done, and then move on to the other one. So I would not ask Ms. Tabaka anything about the other one at this point in time. Correct?
That's fine.
Okay. All right. I don't have any further questions for her at the moment.
Okay. Ms. Tabaka, do you wish to provide any testimony concerning this first show cause filed by defendant?
Yes, Your Honor.
Okay, go ahead.
All right. In the exhibits that I turned in to the courts, I believe it's my first, possibly second exhibit. I don't see my list in front of me. But it's the spreadsheet that looks like this that was provided to me by Attorney Elaine with the
Okay.
dates and the hours.
You have, the first thing, you have a bunch of stuff written on it and you have it marked as, I guess, exhibit 1, is that correct?
It should be, I apologize, I had my list in front of me.
Your Honor, I would object to the omission of this exhibit. First of all, a lot of it is illegible. I'm unable to read it. Second of all, it seems testimonial in nature. She's just taken our exhibit and scribbled all over it. There's things crossed out, which is confusing. There's things that are darkened that I can't see. It's not it's prepared obviously for the litigation. It's confusing. I think it's more confusing than helpful for sure, especially in the fact that I can't read parts of it.
Well, I guess she'll have to testify as to those particular parts, but it is your exhibit that she's responding to, so.
I mean, it's even cut off over on the side. There's writing on the left-hand side that I can't even see parts of the handwriting.
Again, she can testify to that if she wants.
Okay.
Go ahead, Ms. Tabaka.
Thank you, Your Honor. So yes, this is a spreadsheet that I received from you. These notes are for me to explain everything that we just covered a moment ago, but on 11/9/22, the amount of time that you have listed that you are trying to make up for that date is 1 hour. Are these questions I should be asking you or Chris? I really don't know.
No, you're not asking any questions at this point.
Oh.
You're testifying.
Oh, I'm just fine. Sorry. Thank you, Your Honor. You have it listed that you're claiming, Chris is claiming 1 hour. The second date, 11/15/22, the claim is for 1 hour. I'm going to go back up to the very first one and just do these individually. So he's claiming 1 hour of parenting time. And my mother picked the children up for me. Maddie got out of school at 10:50 and Daniel got out of school at 11:50. And it takes my mother a little over a half an hour's time to get back home from Marshall. And so I was home with my children the same time my mother arrived home from picking them up for me. Tuesday, 11/15/22, they're claiming 1 hour of parenting time. The day I worked 8 to 4. The children had piano lessons that day at 3, 3:30, and 4. Meaning the last piano ended at 4:30. So I got out of work at 4. Their piano ended at 4:30. I was home with my kids by the time my mom got home from facilitating those piano lessons. On Friday, the 18th of 2022, a day that they're claiming 3.5 hours. This was a snow day where the schools were shut down. And I had no notice from Chris regarding anything pertaining to that day, if he wanted to get the kids or any offer to travel to get the kids in the weather. And so that's what that is. Wednesday, November 23rd, 2022, they're claiming 6 hours of makeup parenting time. This was a date that I had planned several weeks in advance with Aunt Debbie and Aunt Denise. That they were setting up a play date with some of their kids and my kids. And this play date, this was, again, before the ruling that you made on May 12th regarding me working and not being able to plan anything for my kids during my parenting time. So I couldn't retroactively go back and change that, but I did offer those 6 hours to Chris back in August when they first brought this issue up. Tuesday, 11/29/22, they are claiming 2 hours. And this again was a piano day where the children don't conclude their piano lessons until 4:30 p.m. I worked till 5 and mom got home around 5. So again, we were home at about the same time. Sometimes my mom stops and gets dinner for the kids just to have grandparent time with the kids too. But Friday, December 12th, 2022, they're claiming 1 hour. And let's see, my mother picked the kids up for me. Daniel doesn't get out of school until 3:40. I was out of work at 4, so I was home to receive the kids before my mother even got home with the kids. Let's see, 12/7/2022, they're claiming 2 hours. And this was a day that my mom picked the children up from school and wanted to take them out to dinner. So I just worked until my mom let me know they were on their way home from dinner. Tuesday, 12/13/22, they're claiming 2 hours. This again was a normal piano Tuesday where the last piano lesson concludes at 4:30. And it takes my mom at least half an hour to get home. I ended work at 5, so we were home together about the same time. Friday, 12/16/22, they're claiming 1 hour. I worked till 3:30 that day. My daughter was at school until 5 p.m. because she had a school dance. And my son doesn't get out of school until 3:40. So I wasn't working really at all during a time that would be where there'd be parenting time to Chris there. Wednesday, 12/21/22, they're claiming 2 hours. On this day, Maddie and Daniel, they had math Olympiad and piano lessons after school. So I remained at work longer while they had their extracurricular activities, which their father actually participated in. And I was home when my children got home from those activities. Tuesday, 1/10/23, they're asking for 3 hours. All of the children had piano, which again concludes at 4:30. On this particular day, my mom wanted to take them to dinner, which she informed me, and so I just remained at work until they were done with dinner, and then I met them at home afterwards. On Friday, January 27, 23, they're claiming a half an hour's time. I worked until 3:30 that day. Maddie gets out at 2:30. Daniel gets out at 3:40. So I'll just leave that. They're asking for a half an hour of time. It takes longer than that just to get to Marshall. Wednesday, February 1st, 2023, they're asking for 1.5 hours. I worked till 4:30. Maddie and Daniel, looks like Maddie had piano at 3:30, and then Daniel was picked up, I'm picking up Maddie at 4. They had piano until like 4 p.m. on that day. And again, it takes my mom at least 30 minutes to get home. I worked till 4:30. We were home about the same time. Friday, 2/3/23, They're claiming 30 minutes of time. I got out at 3:30, which is before Daniel even gets out of school, and that's an amount of time takes longer just to drive to Marshall and back. Wednesday, 2:15:23. They're claiming 1.5 hours. Says I worked till 4:30. My mom picked the children up. Daniel gets out at 3:40. And so I left work like about the same time that they were coming home or getting home. Friday, 2:24:23. They're claiming 4 hours. This is the second date in their list where there was a bad snowstorm and all the schools were closed. And it was a Friday, which means that if Chris had even asked for the children, I would have had to travel on those dangerous roads to Marshall with the children and back, and then to Marshall and back, 2 round trips because it was my Friday and my weekend, and the children were already with me. On Wednesday, 3/1/23, they're claiming 1.5 hours. My mom picked up the kids, Daniel, who gets out the latest at 3:40, and I was home at approximately the same time that they arrived home with my mother that day. Wednesday, 3:15, they're claiming 1.5 hours. Again, same scenario. My mother picked the children up from school for me, Daniel getting out at 3:40. And then me getting home at the same time that they would get home with my mother. There was the Monday 4:10 that they have on this list, which of course I expressed in communication in August that Mondays aren't my days, and I don't know why it's on my list. Then Wednesday 4/12/23, they're asking for 1.5 hours. Same scenario as above. My mother's picking up the children for me. And then I leave work at approximately the amount of time it would take for her to get home and me to get home at the same time. On Tuesday, 4/18/23, they're claiming 2 hours. This was a day that all the children had piano lessons, which end at 4:30. And again, it takes my mother at least 30 minutes to get home after piano lessons. And I would have arrived home before or at the same time she was getting back with the kids. Friday, 4/21/23, they're claiming 1 hour. I worked till 4. My mom picked my son up. Daniel gets out last at 3:40. And so I was home before they got home from school pickup. Wednesday, 4/26/23, they're claiming 1 hour. Same scenario. I worked till 4. Daniel didn't get out of school till 3:40. So I was home before my mother got home with the kids. I don't know if I just said this one. 4/28. There's a bunch they have in April. 4/28, same scenario, claiming 1 hour. I got out at 4. Daniel was picked up by 3:40, and I was home before they got home with my mom. 5/5/23, they're claiming 1 hour. They got out at 4 p.m. So same scenario. My mom picks them up. I'm home before they even get home from pickup. Tuesday, 5/16/23, they're claiming 1 hour. And again, I was out by 4 and I was home before the children got home with my mother. And I do believe they added a date after that. Yeah, 5/19, which, as I said before, I got out of work at 2 and I picked my kids up that day. So I'm not sure why that one is even on there. So that's my analysis and what I have gathered from, once I was able to actually sit down and review this spreadsheet that was provided by Attorney Elaine and go through the dates and correspond them to OFW communications and the children's calendar of events. I could break it down and see where all this time was. Most of these dates are on piano days where the children were in Marshall much later than normal. And my mother would facilitate the piano lessons because she's also a pianist. And I would always work it out so that I would be at home by the time my kids got home with my mom from those lessons. I tried to resolve all this entire motion for these hours with Attorney Elaine and Chris back in August. I had put together, and this is in my exhibit, and I'd like to read it if I may. It's an email that I wrote called Answer to Parenting Time.
Objection to hearsay.
I
It's
wrote
her
it.
words, Miss Elaine, how is it hearsay?
Because it has to be offered against herself. If it's a party, the only way it can come in is if it's a party admission she's offering it against herself.
She can answer, I mean, she's giving testimony. She can give testimony as to what happened on these particular dates. So
Right, but at this point, it's a settlement negotiation. The whole email chain is labeled not admissible through MRE 408.
Ms. Tabaka, you can't testify as to settlement negotiations. You can
Your Honor,
testify,
this
you can
isn't,
testify if you offered makeup parenting time, but you can't testify as to the negotiations.
yes, sir. This was not an email pertaining to negotiations. This was an email of me breaking down everything that I just read in that spreadsheet. So, I mean, I could have written this again on a piece of paper to read to you today, but I figured I would just read it because I had it clearly written out in an email that I composed myself, not to Attorney Elaine.
Okay, go ahead.
Your Honor, though, still, she can testify, but it's not proper for her to read something into the record.
Well, Ms. Tabaka, you can testify about this, but you can't have documents that you're reading from that are not, again, exhibits or not in evidence, et cetera. So testify to what you want to testify to.
All right. When I reviewed the entire spreadsheet day by day and compared it with all of the calendars and took into account the outcome, of course, of the May 12th hearing that we had where you made rulings and decisions on the denied parenting time, on what the provision meant, on the specific hours that you did award Chris, on the hours that you did not award Chris, and on things that would not be considered, such as short periods of time that would be consumed by travel, and the where you ruled that Chris could be allowed to facilitate the activities after school moving forward. I considered that because they're disregarding that ruling and using it retroactively. You didn't award those times where my mother helped me with the kids, but you did say that moving forward she couldn't do that. And despite them knowing that, they still included that in this motion against me, and they still included, I mean, most all of the dates that they provided to you. 31.5 of those claims are for periods of time that are 2 hours or less. And also their tally of hours for all of the denied parenting time they're claiming in total did not add up to the 53.5 that she claimed in her opening. I had to count it over and over to make sure I was correct, but there was actually only 48 hours in that spreadsheet that she gave me. So, and again, they threw in Mondays, which aren't my days at all. And I don't know if that was just to add hours to make it look like there was more time that I was denying that was actually factual. The total amount of makeup time in their list for periods of time over 2 hours came to 16.5 hours of time. And 7.5 of those hours, Your Honor, were on those adverse weather days where the schools were closed. Chris didn't request to get the kids. He didn't request to drive on the bad roads to come and pick up the children. And they were already with me and would have been with me for the weekend. So that would have been 2 round trips on those dangerous roads, transporting the children. So, I mean, if you want to count those hours at 16.5, if we don't count those hours, it would have been less than 10 hours of makeup parenting time. And I believe specifically based off of your review of all the hours from the original hearing, Your Honor, I did remember that you did grant him parenting time for the days where I had prearranged family engagements, like with the grandparents or with the aunts. And so one of those days, the 6-hour day on November 23rd, where I had made plans with the children's Aunt Debbie and Aunt Denise to have a play date, I immediately offered up that time to the defendant back in August, of which, of course, that was refused. There was no interest to resolve. So I believe that I put forth very valid effort in trying to resolve this. And I did it based off of how you ruled on the hearing on May 12th. I remembered you said no periods of time that would be eaten up by transportation, short periods of time. And again, the piano and my mom was May 12 moving forward, and that's over half of what they have here. So this, Your Honor, is why I do consider it to be harassment, because I shared all of these facts with the defendant and his counsel for every single one of these dates. I said, but Judge Kirkham ruled no short periods of time, and that seems to be ignored. I mentioned, that the piano and my mother helping out was moving forward, and that didn't matter. That seems to be ignored as well. And again, I did offer time, and it didn't matter. There's no desire to resolve the issue, because I think there's more of a desire to just keep me in court. So
Anything else, ma'am?
no, sir, that's all.
Okay. Ms. Elaine, any recross?
Yes, just a few. Ms. Tabaka, since you and Chris communicate through Our Family Wizard only, can you show us where you offered him the time on November 23rd, 2022?
No, because that was before the judge ruled that I needed to do that. Everything was May
I
12th forward.
Okay, I understand that piece, but you testified just a few moments ago that you immediately offered Chris the time on 11/23/2022. You said from the original hearing, the judge granted Chris parenting time, but you had play dates lined up, and you had a play date lined up on 11/23/22, so you immediately offered Chris that time in August of 2022.
Yes, ma'am, I did, but you requested to Judge Kirkham that
No, I'm just
this-
asking where,
this not
where
be
you-
supplied. This is the email to you.
no, I'm asking you where you offer that up. That's, so if it's the email, that's the answer, but that's what I'm trying to find out. Where did you
Yeah,
offer?
yeah, on August 30th, 2023, when I had counsel, my counsel provided all of that information that I just shared with the court in an email to you in an effort to resolve
All right, so you
matter.
said 2022 a few minutes ago, so you're talking about August
sorry.
30th, 2023.
2023, August
And
30th.
you're saying that Mr. Schaefer wrote an email to me, right?
Correct, because at that time I had counsel.
I know, just, so you're not saying that you told Chris that he could have the time, because this happened afterward. I'm trying to get clear, because I wasn't clear. So you already had deprived him of the time on November 23rd, 2022, and then you're saying you acknowledged that at some point later, correct?
I'm saying that I had used my parenting time to facilitate a play date with the children's family that I did not know was later in May going to be considered something that I could not do. Because
Okay,
as far as I had known since the inception of the order, my parenting time is my parenting time. And if I want to use it for family building and the children getting to see their family, that's normal,
okay. Yep.
common practice.
All right, I understand now. I thought you were trying to say that you had offered Chris the time on 11/23 and he had refused it, but I understand the timeline now. Can you point out to us where in Judge Kirkham's order he said anything about 2 hours or less?
I don't have that order in front of me. I'd recall him saying short periods of time, and especially those that would be eaten up by transportation, the time lost in transportation.
Okay. Let's take a look at the order so we know exactly what it says. All right, this is, I believe, the order after the first show cause hearing. And skip down here. So here's the clarifications and interpretations that Judge Kirkham provided to us. Can you show me there where it says anything about time eaten up by transportation?
Well, I see the provision does not apply to periods of 1 hour or less. I didn't write these orders, so I don't know why the transportation part isn't in there. It would be in the transcript.
Okay, so you don't see it in this order, correct?
No, I don't see it in what you have in front of me.
Okay. So when you testified a few moments ago that some of Chris's claims are for 2 hours or less, you would agree that you don't have a basis for ruling out any of his claims that are an hour or more, right? So if you deprived him of 2 hours, he's entitled to those 2 hours back, or 1.5 hours.
No, Miss Elaine, on those dates where he's claiming those 2 hours or 3 hours, those were dates where my mother was facilitating the piano lessons, and then occasionally would take the children to dinner after piano lessons. And so those are periods of more than an hour, but those weren't included by Judge Kirkham in May, but they were to be moving forward.
Can you show me in the order that Judge Kirkham issued where it says that your mom can pick up the children from school when you're working?
I don't have this document in front of me. All I have is the part where you're showing me, but I can tell you, I do remember clearly, because I found it to be rather disheartening, when Judge Kirkham said that my mother couldn't help with my kids after school activities. So
I think he said she couldn't help with them. I think what he said was, when you are working pursuant to the 2015 order, that is Chris's parenting time. He didn't say your mother couldn't help out in other ways, but where in this order does it say that you're entitled to deprive Chris of time while you're working after school if the kids have lessons or if your mom wants to spend time with them?
I don't know where it would be in this order, but I do recall from the hearing on May 12th that the judge didn't retroactively give Chris the time that my mom had helped me with piano lessons, but moving forward, Chris was granted the right to be the person that can facilitate those activities after school. And if I'm working, and that has not been violated since the judge made that ruling.
Well, where in the order does it say, I'm going to put it back up. Where in the order does it say that future forward, Chris could have the after school time?
Attorney Lane, I don't know where it would say in that. This is what was said in the hearing.
Do you understand, and you may not as a layperson, but do you understand that a court speaks through its written orders? So that only what can be enforced is in a written order, not something that was said in court?
No, I don't know apparently a lot about the legal process, and I'm reading this right now, or I'm trying to process reading this right now. Give me a minute. See, to me, I don't understand why it wouldn't be in there.
Okay, but you agree it's not? And I can show you, I mean, the rest of it is just, the first part of it is how he's going to make up the time, paragraphs 1 through 6. And then these were some explanatory notes that the court gave, and your counsel prepared this, correct? Mr. Schaefer prepared this order. You see that?
I can see that, but I don't understand. I guess, see, because I don't understand how the legal process works. If it was
Okay.
your motion, why he would have prepared the order.
Okay. Let me just double check my notes here. I might be done with my questions for Ms. Tabaka. All right, I am finished with my questions for Ms. Tabaka.
Okay. Mr.
Oh,
Bach, is there anything else that you'd like to testify to?
I guess just the same statements that I had already made, that most of what they're requesting are the short periods of time.
Okay, I don't need you to reiterate and
Okay.
state again, so If it's something additional, the court will take it.
No, I can't think of anything on this particular topic, Your Honor.
Okay, thank you. Ms. Elaine, any additional witnesses?
I will call Mr. Tabaka, but may we have about a 10, 15-minute break, Your Honor?
Okay, we'll take a 10-minute recess.
Okay. Thank you.
All right. Pause for a moment here.
All right, so on the ones that say an hour, these are averages of Maddie getting out of school earlier, Daniel getting out of school a little later, and it turns out to be you're just putting an hour instead of breaking it out into 2 children.
Correct, yes.
Okay. All right, so that's clarification number 1. Clarification number 2 is Ms. Tabaka said our hours didn't add up, and she was right on that, correct?
Correct.
So there was, can you first explain why there were additional hours in the total than actually appeared on this sheet?
Because on Mondays, Alexis just testified that on Mondays I have the children all day. That is not true. On Mondays when the children don't have school, snow days, vacation days, I don't get the children until 11:30 in the morning. So if she's
Okay.
working at 9 in the morning,
All right, that's actually a question about the Mondays I was going to ask you, but didn't you have some rows in the spreadsheet that were hidden and those numbers were actually getting totaled in?
correct.
Okay, so that was an error on our part, right? We had hidden some
Yes,
rows
yes.
because we weren't really sure if she had violated and we just ended up taking them out. But when we hit them, it kept them in the calculation, right?
It messed up the total, correct, yes.
All right. But then we added back in the time from 1:23:23, correct?
Correct.
Which was, I think, a 2-hour, 2.5 hours, right?
Correct, yes.
So for clarification, the hidden rows amounted to 2 hours and we're subtracting that off the 53. So the total should have been 51.
Total should have been 51 in the end, yes.
And then we're adding in the line we erroneously left off, which was 2.5 hours for January 23rd. And that gives us 53.5, right?
No, I'm sorry, Alexis redid the math and came up with 48.5 hours from what we were asking for, and that is correct. Then we add the 2.5 hours to her 48.5, and that gets us to the 51 hours, which is the number.
51's, yeah. Okay, we must have another hidden row in there then. Okay, 51 hours is the errors taken out and the 123 put back in.
Correct.
Excellent. All right, now can you please explain again? I know you just did shortly, but about the Mondays. Alexis testified no Mondays should be included because those are your parenting time days, and your response to that.
On Mondays during summer, during snow days, during vacation days, holidays, well, not holidays because those are
Those don't count.
non-covered holidays, I guess. Alexis doesn't drop the kids off, or her mother or Kyle or whoever drop the kids off until 11:30 in the morning.
right.
So I do not have the kids all day on Mondays. I have them from 11:30 through that night. I have them every Monday night.
All right, so the Mondays you've included on here were morning times where she was working and the kids were off school.
That is correct.
Okay. Now, pursuant to Judge Kirkham's ruling from the last time, you did not include on this spreadsheet morning times that would have been sucked up by the transportation, right? The 1 hour, the half hour in the mornings.
Correct. In our first submission, we included those after his ruling. I went through and cleaned up the spreadsheet and took all that time out. That's why you don't see any morning hours other than the occasional Mondays, which is 2.5 hours.
All right. And with respect to the afternoon time, you heard Alexis testify that Judge Kirkham didn't award you any makeup parenting time for the afternoons where she sent somebody else to pick up the kids. But is that your recollection of what he did?
That was not my recollection at all.
Okay.
I thought a lot of that time that he did, I thought a lot of the time that he did award was from that time.
Yeah, because in fact, he slashed out all of that morning
Yes.
time, correct?
Yes, correct.
And we were left with afternoon time essentially, correct?
Yes, that is correct.
All right. And nothing in the order that we had up on the screen prevents you from asking for the afternoon time no matter what, correct?
Correct.
Is it true, Mr. Tabaka, that you go to the school when it is Alexis's parenting time, pick up the kids, take them to piano, sit there through the piano, go to their activities, and essentially exercise parenting time on your non-days?
No, I mean, I can talk about piano if you like. That's the easiest
Well,
one.
Just, so the answer to that is no.
No.
All right, so she testified that you shouldn't get makeup time for a lot of these times because you are actually with them anyway. True or false?
Could you clarify that again?
Alexis testified that you should not get any makeup time for the after-school times you're claiming because you're there anyway, going to their piano with them and so forth. True or false?
True, that is her claim. True.
That is her claim. Is it true what she's saying that you
No,
are
it's
there?
false. No,
All right.
it's false.
So are you ever at the school after school
Yes,
on when it would be her parenting time?
yes.
And for how long do you remain there?
In the case of, I mean, it's to say hi to the kids or bye to the kids, get lunch boxes. I mean, I don't hold up the kids in any way, shape, or form. I mean, it's like Alexis last night saying hi to Maddie at the tennis tournament, as well as Daniel, as she should. I mean, just it's a hi and bye. There's
right.
no impedance whatsoever.
And then if her mom is there to pick them up, they go with her mom, correct?
Same thing. Yep.
Is that true with regard to the piano lesson days? Her mom comes, she gets the kids, she takes them to their piano lessons.
On piano lesson days, Maddie gets out at 2:30. There's nobody there. Um, she's not there. Mom's not there. I walk Maddie over to piano, which is, I don't know, 500 yards, more or less. Walk her over to piano and drop her off.
All right, and then you leave.
Yeah, and sometimes actually she walks over to the library, which is where I'm at, and says hi and goes to piano from there. So yes,
Okay. She also testified you were with the children, or I don't know if it was one or both of the children at Math Olympiad recently. Was that during her parenting time? Was that true?
I don't remember the specific date. Math Olympiad, no, I'm not at Math Olympiad. That's run by well, it's run by Tracy Martinson at Gordon, and I can't remember who ran it at the middle school, but I don't participate in Math Olympiad in any way, shape, or form.
All right. By the way, has Alexis ever moved to change the transportation provision?
No, she has not.
All right. Is it, so, other than the errors we've corrected on this spreadsheet, is everything else here, a statement of your position of the times that you are owed parenting time you were deprived of under that work parenting time provision?
Yes.
Mr. Tabaka, we spent a lot of time last hearing on the particular provision about notice, right? Do you remember that? The provision says you need to be asking for the children, right?
Yes, I remember.
And we presented a lot of our Family Wizard communications where you would ask Alexis or remind her that this provision existed and you always wanted to exercise the time with the kids when you were working, right?
I made blanket statements like that as well as specific statements. Yes.
And as a matter of fact, you continued to do that. And do you still continue to do that?
I don't currently, after Judge Kirkham's ruling, which pretty much set it in stone that if she's working, then she has to notify me 40 hours in advance. It's no, not currently.
Right. So you're right. So in May, that kind of got changed and the requirements became different for both of you. But up to that point, had you continued to message her in our Family Wizard and
Yes, I messaged her repeatedly. It got to the point where she was calling it harassment, at which point I backed off, but it's a no-win situation. So I continued to still let her know.
were you harassing her?
No, not in any way, shape, or form. I just want to spend time with my children.
Exhibit A, I would move for the admission of.
Okay, and which one is Exhibit A?
That's the spreadsheet that's up on the screen.
The 2 pages?
Yes, Your Honor.
Okay. Mr. Tabaka, any response to offer of Exhibit A?
No, that's fine, Your Honor.
Okay, court will admit defendant's Exhibit A.
All right. I'm going to be referencing now what we've marked as a proposed Exhibit D, Your Honor. All right, this is a series of our Family Wizard messages. It's 13 pages in length. Mr. Tabaka, message 324, this is in our Family Wizard message that you wrote to Alexis.
Yes.
And can you read the highlighted paragraph, please?
As a reminder, our 2015 court order is still in effect. As such, and as per said order, my notification to you in advance that I have plans for the children anytime you are at work remains in place. If they need to go to piano or art classes during said times, naturally, I will take them.
Okay. And 32323, can you read the highlighted passage, please?
With Marshall Public Schools spring break upon us, as a reminder of my prior blanket statements as you referred to them, please consider this ongoing notice that I would like to have the kids at any time, including during break, anytime you are working, as per our 2015 custody order 15-1447 DS. See order itself or prior messages for the exact wording.
And on 4623, your message to her said what in the highlighted portion?
Kindly consider this a reminder as well as ongoing advance notice that as per our standing court order, I would like the children for parenting time at all times while you are working.
And 41423?
Once again, as per our court order, I would like the children anytime you are working. The chaos that has been created and continues with you, not following our 2015 court order, thus preventing me from taking care of the kids' needs, providing consistency they need, needs to end.
42023?
Please consider this a reminder of my standing request, advance notice for parenting time with the kids while you are working as per our 2015 court order, including but not limited to tomorrow.
427?
Secondly, as I've noted multiple times before, as per our 2015 parenting court order, I'd like the kids anytime you are working, including but not limited to tomorrow.
509?
Just as a reminder, per our 2015 court order, I would like the children tomorrow, Wednesday after school if you are working, as well as any other time you are working as covered by our 2015 court order.
All right, so those are some examples of times that you've reminded her that you want the children anytime.
Yes.
Is there any way you think, Mr. Tabaka, you could have made that more clear to her that you wanted the children anytime she was working?
No, I don't believe there is. I mean, I'm in a no-win situation. I don't know when she's working, so I have to let her know that I would like the kids, but there should be no confusion whatsoever that I wanted the children, wanted to continue things as they had been going, or to taking care of them after school and such. So no.
All right. Then we had the ruling from Judge Kirkham on 5/12/23. Do you remember that?
I do.
And then take us through the sequence of events of what happened that week that would pertain to the lines on our spreadsheet, 5/16 and 5/19, especially 5/19, where Ms. Tabaka said she doesn't know why that's on there because she picked up the children.
Oh. So Judge Kirkham made his ruling on the 12th regarding, from the bench, I believe, regarding 48-hour notice in terms of when Alexis was working. And I had 24 hours to let her know that I would like the children, or, I mean, to be polite, of course, let her know that I wouldn't be able to take care of the children during that time. Alexis notified, I'd have to look at the OFW messages.
So this one I'm showing you is from 5/15.
Okay, I think that was in response to Alexis letting me know she was working. Or I might.
I think, well, read that highlighted passage.
Okay.
Maybe that'll jog your memory.
As per Judge Kirkham's judgment regarding our 2015 court order, I wish to exercise my parenting time with Madeline starting at 2:30 p.m. on Tuesday, May 16th, and Daniel at 3:40 p.m. on the same day if you are working in office. So I guess I didn't know at that point.
Okay, so just as a reminder, and I think you were saying this a moment ago, Judge Kirkham ordered that you had to, or she had to notify you 48 hours in advance if she was going to be working. And then you had to respond within 24 hours if you wanted the children during that time, right?
Correct.
Okay. But this is just an advance, or maybe, let's see, let's go down. So she sent you this on 5/15. Oh no, that's you, to Alexis. And this is also you on 5/16. And what was the context of this message?
So at 5:16, that was at 11:30 in the morning. I said, as per the work schedule you sent last night. So she sent me the work schedule via OFW on 5:15 in the evening.
Okay,
You'll be working until 4 p.m. today, 5:16:23. I requested parenting time via OFW with the children today, more than 24 hours in advance. Following school, which ends at 2:30 p.m. for Madeline and 3:40 p.m. for Daniel, pursuant to our 2015 court order, as well as Judge Kirkham's final rulings of last week. Am I to understand correctly that you were denying me my court-ordered parenting time today and that you were having your mother pick the kids up directly after school while you were at work?
all right, so there's must be a message from her in here, and sometimes the threads aren't exactly in order, correct?
Correct.
So let's find hers. Let's see. That was for 590. Oh, here, is this it, Chris? This 519?
No, that's the Friday that week.
That's what we're looking at, right? For the 519 where she
No,
said.
we're looking at 5:16 right now.
Okay, apologies. Okay, here we go. What about this? 516-301. You're emailing her saying you're there and Maddie, no one's there to pick up Maddie.
So at 3 o'clock, I sent her a note. I said, hi, it's 3 o'clock p.m. Maddie's at the middle school with no idea what's going on. Just the same situation Mary Beth and I find ourselves in. I texted Nancy and she said the piano was tomorrow at 3:30 p.m., which is what I had on my calendar as well. I'm going to take Em to get a smoothie at McDonald's and take her to Gordon at 3:40 p.m.
All right, so what was supposed to happen on 516?
I don't know. I mean, I was over there. I never got a response, I don't believe, from my asking to take care of the kids.
All right, and then she
And we
texted
were just
back.
standing at the school. Madeline had gotten out and she had no idea what was going on.
And no one
So I
was there to
sent,
pick her up.
we waited a half hour. She got out at 2:30, 2:32. We waited until 3 p.m. and Maddie was looking around trying to see where her mom or grandma or whoever might be to pick her up. There was nobody there. So that's why I had to send the OFW message at 3 o'clock. At 4 o'clock, Alexis sent the response, which you can see above.
Which she says she's gonna contact the police because you picked up Maddie
On her parenting day, yes, for
when
law enforcement.
when no one was there to pick up Maddie.
That's correct.
All right. Okay, and then you had a similar confusion on 519, correct?
Wasn't confusing on my end because I was following the court order, but yes, it was a mess.
Okay, so what happened in your recollection?
So on Thursday at 9 in the morning, I sent her the 24-hour notice. As per the modified 2015 court order, you provided work schedule working until 4 p.m. on Friday, which is what she had sent me. Please be advised that I will be picking Madeline up from school at 2:30 p.m. and Daniel at 3:40 p.m. for my parenting time. Kindly let me know when you'd like to meet at Denny's for the exchange.
All right. And then,
So I sent another reminder. I didn't hear back from her. So 9:24 a.m. the next morning on Friday, I sent another reminder. Said good morning as a reminder based on Judge Kirkham's interpretation. I will be picking Madeline up after school at 2:30 p.m. today and Daniel after school at 3:40 p.m. As you haven't replied to my last message, questions regarding the time you'd like to exchange the kids at Denny's and with your work schedule taking you through 4 p.m. today, I will plan on being at Denny's at 4 p.m. with the kids. So I was just taking my best shot at how this was all going to go down. I'd given notice. She had given me notice, and I figured I would have the kids until 4.
okay, and then what happened?
At 1:13 p.m., so a little bit over an hour before Madeline got released from school, she said, hi, Chris, I'll be off work and I will be picking Maddie up from school as well as Daniel. I'm also requesting that you are not present at my school pickups during my parenting time. Thank you, Alexis.
All right, so then she switched the game at the end there, right?
At the very end, she, yes, was in complete violation of the 24-hour, 48-hour notice and Judge Kirkham's ruling.
All right, so that's why you're asking for that makeup time, because she offered it to you and then she retracted it at the last minute?
She followed the order and then she chose not to follow the order, yes.
All right. I would move for the admission of D, please.
Okay, Ms. Tabaka,
That's fine, Your Honor.
okay. Court will admit defendant's exhibit D.
And E as well, Your Honor, those were the, oh wait, hang on. Sorry. Okay, so these were the missing ones. It was in a different exhibit. That's why I was struggling a little bit. So I'll just show E really quickly and move for that admission. These were the ones that we were struggling to come up with, more related to 516. All right, is this what you knew existed, Chris, but we weren't able to find just a second ago?
Yes.
Okay, I had moved for the admission of E that fills in those gaps on May 16th that he testified to.
Okay, Ms. Tabaka, any response to offer of exhibit D, or I mean, sorry, E?
No, that's fine, Your Honor.
Court will admit defendant's exhibit E.
Thank you. All right, and in the end, Mr. Tabaka, what is your request to the court as far as your makeup parenting time?
I'm requesting 51 hours with 3 to 10 hours in 3 to 10 hour blocks with at least 7-day advance notice, and not touching any of the prescribed holidays and Mother's Day and everything else that's in the court order.
All right, and have you incurred some attorney fees during the course of these proceedings?
Yes.
And once we have a total number and submit a bill of cost, are you asking the court to find Alexis in contempt and order her to pay your attorney fees for this proceeding?
I am.
Okay. I have no further questions.
Okay. Just to clarify, and then I'll let Ms. Tabaka question you. Sir, you say you want the 51 hours and you're saying in 3 10-hour blocks.
Oh, no, sorry, Your Honor. There's a word that was missing there. 3 to 10-hour blocks of 3 TO 10-hour blocks. So it's a 3-hour block up to a 10-hour block.
Oh, okay. Got it. Okay. I wasn't adding up and I couldn't understand what you
Understand
were
that.
asking.
You could have
Okay.
blamed it on me, more math errors.
Okay. Ms. Tabaka, you can cross-examine defendant.
Thank you, Your Honor. Chris, in the last 2 years, have you been present at every single one of my child pickups from Maddie and Daniel's schools?
I don't know if I've been at every one.
Okay.
No, actually, I haven't.
Have you been at 98% of all of my child pickups on my
Objection.
parenting
Nope.
days?
Objection relevance to Alexis's violation of the work parenting time order.
Okay. Ms. Tabaka, how is it relevant to these particular dates that they're alleging?
Because we would be talking about hundreds of days where he is getting time with the children on my parenting days, which adds up to a large amount of time, Your Honor.
Okay, well, I'm going to sustain the objection. I don't think it's relevant to the times that were missed simply because he was at the school at the time that you picked the children up. So I will sustain the objection.
On piano days, when Maddie gets out of school at 2:30, do you remain with her from 2:30 all the way until her piano lesson ends at 3:30 p.m.?
No, I don't.
Have you ever?
I have. I think it's been about 2 years. I sat through a piano lesson until leaving at about when her piano lesson was over.
On my parenting days, correct?
I would assume so, since you set the piano lessons up unilaterally. I would assume that would be during your parenting time, yes.
Thank you. Do you and Mary Beth participate in popcorn days at Gordon Elementary School?
Objection relevance.
Okay.
Time with the children. I'm getting.
Well, we're only interested in the particular times that have been, again, alleged to be in violation. So any other times are not relevant to this issue.
Okay. Chris, do you work?
Objection relevance.
Okay, what's the relevance, Ms. Tabaka?
He sends emails claiming any and all times. And so if he has a job, how am I to know that any and all times are actually available for Chris to even watch the kids?
Well, I think it is not relevant because, again, if he's asking for those particular times and he's able to adjust his schedule, even if he's working to take those times, that would not be germane. So if you could establish that the times under the exhibit that he had asked that he was not available, then that would be something else. But at this point, just ask when he's working, and that I don't think is relevant.
Sure. Right. Going back to the spreadsheets that you provided to the court, same that I use for my exhibits. Despite this new interpretation of 1 hour meaning 2 hour, what was provided to me and what was provided to the court are claims of 1 hour blocks. Is that correct, Chris? On this spreadsheet on November 9th, 2022, do you claim 1 hour makeup time owed?
Yes, that's the average out. Yes.
On Tuesday, 11/15/22, are you claiming 1 hour?
Again, the average of 1.5 and a half. Yes.
Objection to cumulative, Your Honor. The spreadsheet has been admitted as an exhibit. It says what he's claiming.
Well, I think she can ask for clarification, so go ahead, Mr. Tabaka.
Okay. On Friday, December 2, 22, are you claiming 1 hour?
Again, on average, yes.
Please just answer pertaining to what you have on your spreadsheet. On Friday, 12/15, are you claiming 1 hour? 12/16, it's 12/16.
12/16, yes.
On Friday, January 27th, are you claiming a half an hour?
Yes.
On February 3rd, 23, are you claiming a half an hour?
Yes.
On April 21st, 23, are you claiming 1 hour?
Yes.
On April 26th, 23, are you claiming 1 hour?
Yes.
On April 28th, 23, are you claiming 1 hour?
Yes.
On Friday, May 5th, 23, are you claiming 1 hour?
Yes.
On May 16th, 23, are you claiming 1 hour?
Yes.
On May 19th, 23, are you claiming 1 hour?
Yes.
Based off of the order that Attorney Elaine put in front of me that I do not have, it did say periods of time of an hour or less are not to be counted, correct?
Correct.
Okay. So knowing that, why would you knowingly have all these 1 hour requests which violate the ruling of Judge Kirkham's order on May 12th?
Because asking for an hour and a half for Maddie every day and a half hour for Daniel every day, I tried to make things as simple as possible in terms of combining those two. It's an hour and a half on all those days except for 1 or 2 for Madeline. So if I had just gone after that, I suppose I could have done that and asked for more time with Madeline. I just averaged them all out. That's why we ended up with the hour.
Correct, but this is the official document that you submitted to the court and submitted to me in reference to the hours that you claimed are denied, correct?
Correct? With
Correct.
all the times on there, yes.
Some of the times being half an hour amounts. Correct?
I believe it was one.
January 27th. February 3rd.
Correct, there too.
So wouldn't you agree that putting in times like that, requesting times like that are again against the judge's ruling and rather frivolous?
The judge's ruling as of May 12th. Again, Madeline was out at 2:30, so that's an hour. 3:30 and 2:30, that's an hour. So yeah, I could drop that, those 2.5 hours.
Didn't you admit to your counsel that you would spend time with Maddie after she got out of school over to the library and then from the library to piano?
I used to do that. I used to walk her from school to piano. Over the last, I don't even know how long. I've been meeting her at the library and just walking her the short distance to piano.
Mhm. And you would sit in Nancy's classroom for these piano lessons with Maddie during
recall
this time,
sitting,
during this time period.
yeah, during this time period, I recall doing that once. I remember sitting through a entire practice session.
Okay. And I don't, the original paperwork that your attorney gave me, which has been altered since August, the Monday that was claimed was a school day. And so in fact, nothing of the 11:30 exchange pertained to that. Was there another Monday added later on that was not a school day?
On 4/10/23, Alexis, you wrote, I do not even have kids on Mondays, including this date of 4/10.
Right. That was a school day.
Okay, and then the other one was, I believe, 1/23, which I believe might have been a snow day, or might have been Martin Luther King Day, actually. It might have been Martin Luther King Day based on that date.
1/23?
I have to refer to Natalie. I don't have it in front of me.
I've got the original spreadsheet that was provided to me, which had the Monday of 4/10, and then the second spreadsheet that was provided to me when you guys first filed your motion. But I don't see one that has an alternate Monday where the children would not have been in school. But
I think we covered that about an hour ago during testimony, during your testimony.
yeah. Okay. All right. And is it true that I offered and communicated through my counsel to resolve this matter with you in August?
Objection with regard to settlement, inadmissible settlement negotiations.
Well, I'll let him testify whether she offered, not what the substance of it was.
Could you ask the question again?
In August, were there communications regarding resolving this denied parenting time?
The only resolution or the only resolution I remember, or the only attempt at a solution, was offering a couple hours on a Wednesday. That's all I remember. It was not significant. It wasn't truth faith negotiations, in my opinion.
Okay. All right. That's all I have, Your Honor.
Okay.
Thank you, Chris.
Mr. Tabaka, I have a couple questions. First, you just referenced that on January 23rd, there was, you believe that was a Monday and there was some issue as of Martin Luther King Day. But I'm looking at your sheet, you don't have January 23rd listed.
Yes, sir. I don't believe it's on the sheet. I believe Miss Elaine pulled it up earlier during Alexis's testimony. And I don't know that that's Martin Luther King Day. It might have been a snow day. I just remember Alexis worked the full day and had the kids until 11:30, which is why I asked for 2.5 hours relief for that time.
Well, it's not on your list, so you didn't ask for that particular time because it's not listed anywhere on your exhibits.
Okay.
Is that true?
That's not on the exhibits that I'm seeing either. No, sir.
Okay. And you said that when you take Madeline to piano, that you'd walk her from school to piano, and it was asked about whether you would stay during that time. You said you'd only sat through the piano practice once. Is that correct?
Yes, that's all I remember was one time. I would walk her over there. Sometimes I would say hi to Nancy, but I wouldn't stay for the piano practice itself.
Okay.
I do remember staying one time and talking with Nancy about her dolls and such, but that's the only time I remember.
Okay. Those were the only questions I had. Any other questions as a result of mine, Miss Elaine?
Yes, and as a result of Ms. Tabaka's. Mr. Tabaka, that one date that's in question was the 1/23 of 23, correct?
It was 1/23. I can't remember if it was 23. I believe so, yes.
Yes, and you testified earlier that we inadvertently left that off the spreadsheet, but wish to have it added today, correct?
That is correct.
So if you reference the time cards, Your Honor, it's the 1/23/23 date, which is page 13, is the date that was left off that he added. And if Your Honor doesn't want to include that because it wasn't on the spreadsheet, I understand, but I'm just trying to clarify why that date got added today.
Okay.
All right. And Mr. Tabaka, have you been accused by Alexis of stalking her or harassing her by coming to the school during her parenting time?
I have repeatedly.
And those times that you should have been afforded the parenting time, if she was actually affording you the parenting time, you would not be subject to those threats of harassment and stalking, correct?
I would not. And also, most of the time, she doesn't pick the kids up. It's her mother or somebody else.
Right. But if she had just been saying, I'm working, you can have the kids this day, we wouldn't have an issue with accusations of stalking and harassment and threats and that sort of thing, correct?
That is correct. There'd be no crossover, which everybody wins.
All right. I have no further questions.
Okay. Ms. Tabaka, any other questions?
Well, yes, I do have a question. I don't know if it's proper or not, so correct me. My request to you, Chris, not being present at the school is because.
Ma'am, it's not a time for you to explain. It's time to ask questions.
Yes, sir. Then I'm fine. We can move forward.
Okay. Okay, thank you. Conclude your testimony. And sir, Ms. Elaine, any additional witnesses?
None, Your Honor.
Okay. So does that conclude your presentation of your case as it relates to your show cause?
Yes, it does.
Okay. With that, we'll go to Ms. Tabaka. This is your opportunity to present your evidence as to your show cause.
Okay. May I invite a witness in to begin with?
Who would you like to testify?
I will start with my mother because she's just the easiest to get a hold of. In between, may I break to contact the other witnesses so they know to zoom in.
We can do that. And what is your mother's name?
Mary Ruth Goldstein.
Okay, she's not on.
I have Joan Bowers, Denise Mackey, and Mary Golds. Is that somebody else or is that?
If Joni is on and in the waiting room, we can do her first. I know she'd like to get back to work, so.
Okay, so let me bring her in.
And who is this?
Joan Bowers.
Okay,
And just to be clear, Your Honor, we are on Alexis's show cause against Chris at this point, correct?
correct.
Thank you.
Your Honor, may I ask you a question? With regard to my witnesses are to provide information regarding all the motions being heard.
Okay,
Is-
I will allow that.
Okay, it's all kind of connected, so. Yeah, if Joni is there and she's available and ready.
Okay, okay. Ms. Bowers, we're going to take some testimony from you, so we'll have you raise your right hand, be sworn in, then we'll proceed.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
I do.
Okay, go ahead, Ms. Tabaka.
Thank you. Hi, Joni.
Hello.
How many years have you known me?
I'm a little over 13 years
And in what capacity do you know me?
as a coworker and a friend and your supervisor.
Okay. And would you say you have been a witness to many of the events of my life from before the children were even born to present day?
Yes.
And about how long has Chris Tabaka interfered with my work or made attempts to cause me to lose my job?
Objection, Your Honor, to relevance.
Okay. Ms. Tabaka, this doesn't go to either of the motions, and it's not been alleged in any of the pleadings, so I don't know where you're going with this.
It has to do with the harassment and abuse, and that is truly the intent of Chris in this motion and basically all the motions that have been filed in the last 3 years. But I wanted to present to the court that this man does in fact actively harass and abuse me, and that's what this is. That's why we're here today.
Well, that's not the subject of either of these motions, so I'm going to sustain the objection, address only what we're here today on, which is these two motions.
Okay. Joni, did I go on personal leave from the department in May of 2023?
Yes.
Can you explain a little bit the nature of why I went on leave?
Objection, based on the ruling as to my motion in limine that Ms. Tabaka may not present information about her medical or mental health, I would object to any testimony explaining her Family Medical Leave Act reasons or anything surrounding that.
Well, yeah, I'm going to allow it for a limited purpose, only that she did go on leave and what her stated reason was. I won't let it go into, again, the specifics or any diagnosis, prognosis, or anything of that nature.
All right. And the other thing, Your Honor, is that there's no time after she went on leave that we're requesting, because obviously she was on leave, so the relevance is marginal, if any.
I know. Well, I'll take the testimony. Go
All
ahead.
right.
Sorry,
It was,
Joni. Go ahead, I apologize.
she went on leave due to all of the stress that Chris was causing her through the courts.
Okay.
Did I quit my job at the sheriff's department?
No, absolutely not.
And am I still employed by Calhoun County at this time?
Yes, you're still on the employee roster. You're still on the seniority list. You're still
Okay.
employed.
Thank you, Joni.
You're welcome.
That's all I got for today.
Okay. Miss Elaine, any questions you have of this witness?
Done.
Okay. Ms. Bowers, that concludes your testimony. Thank you, and you're free to go. Have a good day.
Thank you.
Thanks.
Next witness, Ms. Tabaka.
Yes, give me just one moment to go let my mother know to zoom in, or was she already in the waiting room?
Denise Mackey, Mary Golds.
We can do Denise first.
Okay. Just unmute your device, ma'am, so we can hear you.
You still need to unmute, ma'am.
Okay,
Okay, we can hear you now. Ma'am, we're going to take some testimony, so I'll have you raise your right hand, be sworn in, and then we'll proceed.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
yes.
Go ahead, Ms. Tabaka.
Hi.
Hi, Alexis.
Denise, how long have you known me and my children?
Lily's 7, so I would say about 8 years.
Okay. And in what capacity do we know each other?
You were married to my nephew, and you live just around the corner from my parents, so I see you frequently.
Okay. And what do you do for a living?
I'm a retired nurse. I was in pediatrics for about 25 years of that 39-year career.
Thank you. And have you ever witnessed Chris and Mary Beth to be at all the child pickups that you have attended?
Yes,
Objection, vague timeline, all the child pickups that you have attended. If we could just get.
Yeah, we're going to need some clarification as to the dates, Ms. Tabaka.
Sure. There's one specific date because it is on their list, and that is November 23rd, 2022, where he is claiming 6 hours of denied parenting time. Aunt Denise and with her sister came to pick up the children for the play date.
yes, they were both, Chris and his wife were both at the pickup when I went to each school to pick up the kids.
Okay. And are you aware that Chris is claiming denied parenting time for that day that we had?
Relevance to what this witness knows about Chris's claim of denial. It's not relevant what she knows about it.
Ms. Tabaka, what's your response?
I don't know, Your Honor.
Okay, well, the court will sustain the objection then, so move on.
Okay. Is it true, Aunt Denise, that Chris Tabaka followed you and showed up at the McDonald's where the play date was taking place?
Objection, relevance.
Okay, Ms. Tabaka, how is that relevant?
Just that he's always involving himself in time that is during my time, Your Honor.
Well, I guess I'd say it's only relevant if you were present, Ms. Tabaka.
Okay. Aunt Denise, of your personal observations of what is your observation of Chris's behavior regarding the children?
Objection, relevance.
How is it relevant, Ms. Tabaka?
Aunt Denise is a witness to Chris claims that he's very passive in these times where he's there at my child exchanges, but Aunt Denise and other family members have witnessed that he spends a generous amount of time with the children, preventing them from timely coming to me on my parenting days.
Okay, well, if you can get the specific days that correlate to Defendant's Exhibit A, the court would hear that testimony, but I don't want generalization or just any particular days, as it sounds like the question is, so. If you can correlate it to those particular days as to when there was a denial, the court will hear the testimony.
Yes, sir. Specifically for the list of dates that they provided, November 23rd, 2022. That child pickup, did you observe Chris to spend a generous amount of time with the children before the children came to you for
I would
Take
object to the nature of the leading question too.
Well, just ask her what amount of time you spent, Ms. Tabaka. That won't be leading then.
how much time did Chris spend with the kids at that child pickup?
Oh, it was him and his wife, and they were at each school when I went to get each child. I don't know, maybe 10 minutes, I would guess,
Okay,
at each pickup.
all right. I think given the direction, I think that's probably going to be it for the questions today. Thank you.
Okay, Ms. Elaine, any cross?
Just one. Good afternoon, Mackey.
Mackey,
Miss Mackey, on 11/23 of 2022, first of all, that was quite a while ago. How do you recall that date?
Well, I can tell you anytime I've gone to pick up the kids at the school, Chris and Mary Beth have been there. So it'd be no different than any other time I picked them up.
So you don't have a specific recollection of 11/23/22, you're just testifying from your general experience?
Yes.
Okay, and
Although I could look through my phone for pictures and I would know probably what we did that day and could probably give you more information.
I have no further questions.
okay, thank you. Anything else, Ms. Tabaka?
No, sir.
Okay. Ms. Mackey, that'll conclude your testimony. Thank you. You're free to go. Have a good day.
Thank you, you too.
Next witness, Ms. Tabaka.
Okay. Mary Goldstein.
Sheehan.
I have a Mary, is this?
We have a Mary Golds, is that?
Yeah, that would be her. Yeah.
Okay,